decide, based on what they have said, what am I going to do about that in my bundle, in a witness statement, and in my cross-examination. So we do that to basically, you do it to prepare for, sorry, I've gone live on YouTube, but I'm so blurry. I am bringing chaos to you all today. I'm so sorry. Okay, hold on. Let me just see if I can fix this. I'm so sorry for being so chaotic, team. Like, we're going to get there. We're going to get there, and then we're going to bring in our YouTube friends. And I'm not going to be a big blurry mess for our YouTube friends. And everything's going to be okay. And, it's not going to be quite as ridiculous as... I'm better. It's all better. Okay. Let me see if I can get this all sorted. The problem was I went live before I had everything set up because I didn't want to be late. And then honestly, like I'm okay. Right. Let me try again. So I was answering I was answering a question about the COT 3. So that's what I mean when I say we don't check the COT 3. But we can help you prepare for your witness statement, can help you prepare for your cross-examination. That's what our tribunal coaching packages are for. So let me know if that answers your question. After you get the ET3, how long roughly is it until you get a preliminary hearing? Great question. The tribunals have been pretty slow lately, so like maybe a month or something like that. But if you haven't heard back in over a month, I would check in with the tribunal. Although, as some people are saying, the tribunals sometimes don't answer their phones, but keep trying. And I have actually heard some people, if you are near enough, are just rocking up to the tribunal just to ask questions because their phones are not getting answered sometimes. Right. So I have my work laptop after being terminated. I want to request GDPR to access my data. Do I have to give the laptop back and wait for their response? Good question, user 773. I'm trying to... If there is data on there that is your personal data, I would struggle to see why you would give it over and then ask for it back, if that makes sense. And depending on how they're actually, monitoring these sorts of things, I don't know how they would know that you have taken your personal data off of it. You want to be very careful that you're not pulling off anything that could be company confidential secrets or proprietary information or things like that. But in terms of your own personal data, so emails going back and forth, things like that, I wouldn't I would struggle to understand why you would need to hand it over and then ask for it back, because they're very likely to not give it back to you, or at least make it very difficult for you to get it back. Is that the question you are asking? Do you have a template for the disability impact statement? Hello, YouTube people. Hello. I started a bit late, so I've just dove straight into questions. If you haven't met me before, my name is Danae, and I help people who are representing themselves or working with lawyers, but managing most of the case themselves for employment tribunal. And I have a platform called VALA, which helps people represent themselves. I am not a lawyer. I hope everybody sees that. I am not a lawyer. I am a technologist who saw a lot of people getting screwed over by their employers. And I got really pissed off about it. And we built VALA so that people who couldn't afford to go the traditional law firm route could still get access to justice. So quick introduction there, just for anybody who hasn't met me before. Right, so Shar says, no offer yet, solicitor logged it with ACAS. Is it the employer that makes the proposal or the employee? It can be either. It can be either, Shar. And so if you've got a lawyer who's looking after it, if there's not an offer on the table, then they'll probably send an offer and indicate, it's called a without prejudice conversation. So they would probably have that, open up that without prejudice conversation with a letter. And in terms of how long it takes, once that offer is out there, your employer could ignore it. They could jump right on it. They could immediately counteroffer. It's so hard to tell But it sounds like if you've got a solicitor who's done this before, it sounds like you're in good hands for them to look at that offer. But make sure you understand what they're putting into that document. Make sure you understand what the schedule of loss or the proposed figures are and why they're there. Just because you're working with a solicitor doesn't mean that you don't get to understand what's happening, if that makes sense. Okay, my respondent have refused to take part in early conciliation. Is this normal? So that's a similar question about early conciliation negotiations for settlements. Yes, it is normal Unity for an employer to not take part in early conciliation. They're not required to. The early conciliation is basically it's a pretty new thing. It was only put in about 10 years ago, something like that. And it's the government trying to reduce the number of tribunal cases by forcing both sides to at least get the option to negotiate a settlement before they move forward. And that's why you have to have the ACAS certificate to file almost all tribunal claims, because they want you to at least go through the initial part of that process, even if one or both of you declines to go through it. It doesn't look bad for either one of you that you have declined it. And it's okay if they have declined it. Often it just means that they don't know enough about how strong or weak your case may be in order to then, decide if they want to make an offer or accept an offer. One more from TikTok, then I'll switch to YouTube. Lulu, we do read the DMs on TikTok, but actually you'll get a much faster response if you email hello@vala.uk. Because I've got a whole team of people looking after that email inbox, but only one person looks after the TikTok DMs. Georgie says, I'm going to settle. They have offered a fair amount, but the terminology is so confusing. So this is exactly what I was talking about with Shar, Georgie. The terminology is confusing. So Georgie, a few things that you might want to do. I've got a free webinar on our website called How to Settle with Your Employer, and that will use some of the terminology that you might see in that offer. Some of the terms that you might see are past losses, future losses, injury to feelings, basic award, loss of statutory rights. So those are all terms that you might come up against. We have a glossary on our website as well that will have a lot of those covered off as well. So definitely, it's okay, even if you have a solicitor, to ask about these terms, Google these terms, use some of our free resources to help understand what these terms are. And if you do want a second opinion, our merits assessment service, and this is for everyone, our merits assessment service is basically there to help people price settlements and potential tribunal claims to understand if they want to take it forward. It's designed for people who are in that kind of grievance failed, disciplinary failed, dismissal, ACAS early conciliation stage, where they're like, do I file this tribunal claim? Is it worth going forward? Should I settle? How much should I settle for? So if you do want one of our team to have a look at that, it's called Merits Assessment. And if you go to the homepage of vala.uk and scroll down, you'll see it as a little box. Okay, let's look at the YouTube folks. Hey, Chanson. Hey, fellow ADHD are checking in. Hey. Maggie. Hey, Maggie, great to see you. So Tina says, my substantive preliminary hearing is next week, and the respondent's lawyer sent an email today informing me that a counsel representative will be representing the respondent in PH. Can I object to that? On what grounds would you object to it, Tina? Because the thing about employment tribunal is that you don't have to have any qualifications whatsoever to represent someone else in employment tribunal. And in fact, I know people who have represented their mums, for example, and it's they have no legal qualifications or anything like that. So it is quite normal for someone to, maybe be an HR person or be a lay person in general that just has some tribunal experience who might do representation. So on the face of it, I don't see any red flags there, but I'd be interested to know if this particular person was a problem or something along those lines. Carla says, I'm following your lives and they are great. Thank you, Carla. I have many strategic questions I need to advise before filling out the ACAS early conciliation to start the process the right way. Okay, great. So And this is a really good point for everyone. Do we have a disability impact statement template? We don't have a template, but we can absolutely help you write that. As I'm assuming, and this is the I'm assuming that you're preparing for a substantive PH. You can use our substantive PH prep package, which is on the coaching page on our website. And we have helped loads of people write disability impact statements through that coaching package. So it's substantive PH prep. So you don't really need to do a ton of prep before submitting a CAS early conciliation, Carla. And this is really important for Nawaz, who's doing it tonight as well. ACAS early conciliation, the most important thing about that is that you hit the deadline, that you do it before the 3 months minus 1 day. And when you actually go to fill out the form, I actually have a video on TikTok that just shows what the form looks like. So you can kind of get a preview before you go and do it. It's very simple and it's very straightforward, and it's very not huge. Is this about Scottish law? No, this is about we cover England, Scotland, and Wales with our support for Employment Tribunal. So, Carla, I wouldn't worry too much. What they ask you to do on the form is to just lay out the problem and the issues. And then a person is going to call you, and then they're going to go talk to the other side. What you send in doesn't get like forwarded on to the other side. So I think the more important thing is to just lay out the basic issues, try not to write too much, and then get it submitted. Then you can talk to someone, but the stakes start to get high when you want to start spending more time or potentially more money to avoid mistakes. That's the point of the ET1 tribunal claim form, and particularly the particulars of claim section. I think it's called section 8.1. That's where you do want to spend some time to prepare to make sure that you get it into the format that the tribunal wants. But ACAS early conciliation, the stakes are way lower for how you present your case or anything like that. So I wouldn't worry too much about that. I would just get it in. I hope that helps, Tina. Oh, we got loads of questions over on YouTube. Let me just answer a few more, then I'll come back to TikTok. Thank you all for being with me here today. So good. Ginger Ninja, hey. As a claimant, can I apply for a strikeout due to the respondent requesting an adjournment due to having pneumonia and not coherent, although on the day of the final hearing, she was at work and also reported me to the police? Good God. And had a meeting with an officer on the day of the hearing. Should have been. She was clearly coherent and not ill at all, and the meeting was online. Holy shit, y'all. Ginger Ninja is spilling the tea. Yeah, if you can prove... So the short version is, yes, as a claimant, you can apply for a strikeout just as much as a respondent can apply for a strikeout. Now, for those of you who don't know what I'm talking about, the Employment Tribunal has something called the Employment Tribunal Rules of Procedure document. It has 2013 written on it. Employment Tribunal Rules of Procedure is what you want to Google. And that's the rule book for employment tribunals. And if one side takes the piss, like that's the unofficial way of phrasing it. If one side takes the piss, then the other side can ask the tribunal to throw out the whole case in their favor because one side has taken the piss. Now, Ginger Ninja, it certainly sounds like one side may have taken the piss here with the court's time. And the court is very, very unimpressed if someone has wasted their time because there's a backlog of cases and time is precious. So assuming that you have, information that you can use to back up for the tribunal what you're telling me here, then yes, I do think it's probably worth filing for a strikeout. They've made claims that I have hacked their emails. Jesus Christ. So yeah, we do have a strikeout template. I don't know, I can't remember, Ginger Ninja, if you're working with one of our coaches. We do have a strikeout template, and you can pay a little bit extra to get one of our coaches to review it for you if you want someone to, or you could go straight to, because it sounds like you're pretty far in the process, or it might be worth getting one of our tribunal coaching packages and just talking through the tactics with one of our coaches, because our coaches are all experienced litigators in the employment tribunal. They they work with the judges, they've represented respondents, they've represented claimants. And so if you really want to talk tactics like that, that's always what I recommend that people do, is go to our coaches via the coaching packages and really really talk details with them, if that makes sense. But it sounds to me like you've got grounds for a strikeout application. That is absolutely ridiculous. Okay, so let me answer some more questions. Right, so I answered the question about the disability impact statement. We don't have an official template, but we do support loads of people through our preliminary hearing prep package, which is the substantive one. It's a little bit more expensive, but that's because we take more time to help you write that document. I was provided privileged information that showed the employer legal team lied, but not allowed in tribunal. Shawnee, I skipped yours. Are the hearings always in person? No, it can be online as well, and you can actually make a request for it to be one or the other. The tribunal doesn't have to honor it, but you can request it, and we have a template for that online. Okay, on our website. I was provided privileged information showing the employer legal team lied, but not allowed. So Jaffa Cakes, was that part of a protected conversation? So what I would look for is sometimes the information that you're provided via a protected conversation is not actually protected, because they're either using a protected conversation in a way that isn't genuinely trying to reach a settlement, or they are being super broad and trying to protect everything under a protected conversation, which is not what it's for, or they're using it to kind of intimidate or bully you. So I don't know if any of those feel like they're relevant for you, but there are cases where you can ask the tribunal to basically unprotect the information. And Donna, who is my co-host on the Employment Tribunal Support Group, who represented herself against Morrison's, she did this. So that is possible, so I would have a look at that. What can you expect for the first preliminary hearing, and how do you make sure that you're prepared? Great question, Tom. And I do have some videos on TikTok where you are about this. If you look back, you'll see preparing for preliminary hearing videos. The big thing to remember about a preliminary hearing, and I'm sure other people in the comments who have done it will tell you, it's not like a courtroom drama kind of a meeting. Oh, thank you. It is a chilled out business meeting most of the time, where you're just getting your ducks in a row so that you can do the rest of the case. So it's about scheduling, it's about making sure all the paperwork's in order, everybody's got the names right, all that kind of stuff. So generally it's not a big deal. And the thing that you want to do to be prepared is they should have sent you a case management agenda. And again, I have videos about the case management agenda. That's what you want to fill in. We do have a preliminary hearing preparation service, which is where our coach will help you work through that agenda. By far, the most important part of that agenda is the list of issues. Again, I have a video about that as well. And that is where you really want to lay out the legal issues that the tribunal will need to consider to determine whether or not you win your claims. So happy to go into that in a little bit more detail later on, but I do have some videos, and our coaches definitely can support you with that. Do you have a template for discrimination because of anti-Zionism? So anti-Zionism would fall under a protected belief. Well, and you could argue that anti-Zionism would fall under a protected belief. Now, religion is one of the 9 protected characteristics, but it's not just religion. It's religion and protected beliefs. And some examples of protected beliefs, for example, would be veganism, and that has been come out in court as a protected belief. You do need to kind of cross a few hurdles to show that it is a significant part of your identity. So, for example, if you're attending marches regularly, if you've got a big part of your kind of life is activism, things like that, then that probably would fall under that category for you. So I would look into the 6 types of discrimination, which I have a video about, and the protected characteristic of religion and protected belief. If you email HR for a termination, can they refuse to provide this? Barb, do you mean a termination reason or a termination? Your employer is not required to give you a reason for your termination before 2 years of employment has passed. After 2 years of employment, they do have to give you a termination reason. Before that, they don't have to give you a formal reason, although obviously, if they do it for a reason that was discriminatory or because of whistleblowing or because you used a protected right, like flexible working requests, then even if they didn't give you the reason, it can still be a automatically unfair dismissal. Okay, let's keep going. My employer won't provide my HR file after requesting it. I'm going to tribunal later this year. So there's a lot of, I saw that there was a wee bit of DSAR questions and things like that around this. So you can use a data subject access request to ask for this information, and your employer should provide it within 30 days as part of their obligation as part of the GDPR. If you want to know more about this, I do have some videos, and we also have a free data subject access request template on our website, which also has a course built into it, and you can watch videos to understand exactly how to do that document. So I would start there. If you are going to tribunal later on, you will have an opportunity via the disclosure process to ask for those documents as well. And something as basic as your HR file, the tribunal is not going to be impressed if the other side can't come up with that document. So you will have another opportunity there. Do you have any in-person meetups? Jazz, we were thinking about this recently, actually, and I am wondering if I should do one in London whilst I'm down there. And obviously, I'm up here in Edinburgh and would be totally open to doing something like that. Hold on, I'm just going to go close my door because my poor husband's going to get annoyed because I'm talking so fast and loud. Okay, next questions. Right. Okay, so I see a lot of people recommending. Jaffa Cakes is saying DSAR is a waste of time. Sometimes it is and sometimes it isn't. It really depends on the employer. And depending on how much they take it seriously, you can complain to the ICO if they don't honor the DSAR. The ICO don't do much about it, but you can go pretty far in the complaints process. And it doesn't, like, depending on the company, they will immediately comply, or they will drag their feet, or they will ignore it. But you have a legal right to request that information. Okay, right, let's go back over to YouTube. Hi, Natalie. I have been asking for a few Teams messages, as I know I had a conversation with HR around them not following their own capability process. Now, respondent are saying that the messages are deleted after 1 year and therefore cannot access. Should I let this go and include emails in the bundle? The messages are important. I'm showing that I flagged them not following process. Well, those sound quite important. I take it, so your account of remembering that you had the conversation can still count. And obviously it would be better if you could have the actual Teams messages. So I would still put into the bundle your account of what you remember and how much information you can remember. And you can also highlight, I have requested this, but the employer has said that it is not there. The other thing that you could do, if you haven't already, is you could use something called a request for specific disclosure, where it's not just that you're asking the respondent to do it, but the tribunal, you can ask the tribunal to order them to look for it, look in their backups, all that kind of stuff. So it might be worth doing that if you really want to push it, because it sounds like it's pretty important to your case. And the more important you think it is to your case, the more the tribunal will get annoyed if the employer looks shady about not providing it to you when realistically they could. But either way, if whatever you remember about those conversations, write down the who, what, where, when, and say, this is my recollection of this conversation. Obviously, I would love to prove it to you, but my employer conveniently says that it's deleted. Okay, JC says, I filed an ET1 for discrimination, but heard you need another ACAS conciliation for constructive dismissal, as have put both on the same ET1. No, it's just the one ACAS early conciliation. You can make multiple claims on one ET1. I think what you might have heard is that if you need to make a claim later on, then it might need to be a new claim, or you could ask to amend your original claim and add it on. But no, you can do, so if you need to add something on later, you might have to go through the process again, and unless the employer or the tribunal allows you to amend your claim to add that new element. But if you have one set of problems, one ACAS early conciliation will take care of that. So say you have like a, Donna, who took on Morrison's, she had pregnancy and maternity discrimination, sex discrimination, and constructive dismissal. Those, I think she amended her claim once to get one added on, but she had at least two in her original ET1. And you can definitely do multiple claims in one ET1. Right, so Chanson says, I'm on a massive ADHD hyperfocus, prepping timeline, evidence, draft ET1 before booking a coaching package. Struggling to make progress as I can't stop myself getting everything perfect. Any tips? Okay, great question here. So if you're drafting your ET1, it depends on what you mean by perfect, because the thing is, like, you don't, and somebody asked a question, Anna asked a question on TikTok, which is relevant to this. ET3 is factually wrong. Do I wait for the preliminary hearing? You don't actually address the facts, the super, super, super specific facts, until way later in the bundle, in the witness statement, assuming that you are writing one and you're not in Scotland, and the cross-examination. The thing that you want to get right for your ET1 is much more around the claim, labeling the claim very specifically. So not just saying, I was victimized or I was treated badly, but saying I was directly discriminated against as per section blah of the Equality Act. Here is my comparator, because the legal test for that is a comparator. Or I was victimized according to section blah of the Equality Act. Here was my protected act, because the legal test is that you have to have a protected act and a detriment. And here is the connection between those two. So each claim has very specific criteria that says, okay, this is why I think they broke this law. That's what you want to worry about right now. Not, getting every single thing perfect, if that makes sense. So yeah, I think what I would spend the time on, Chanson, is really understanding the legislation. And that's why we have that My Claims section inside the platform, so that you're able to kind of work through that. And we list the exact legislation and the exact section of each legislation, so that you can go and read it and you can start to understand what the rules are and where you think you fit into the rules. But an ET1 should only be a couple of pages long, maximum, realistically 5 pages or something like that. You want to keep the claim, particulars of claim, pretty short, because you just want to make sure that the tribunal understands in their language what laws you think were broken and why. I hope that helps. Right. Let's see, more questions. Do I have a case if I was originally denied statutory sick pay and had to fight for it? It depends, G, on why you were denied it, and if they eventually paid. So let's say, for example, that you were owed £1,000, and eventually they paid you that £1,000, but in the meantime, you ran up some other debt because you had to cover your bills and it cost you another £500. You could theoretically still take them to tribunal and say, I would like reimbursement for my past losses, because had I been paid in time, I would not have incurred these losses. But you would need to put a specific pound amount to it. In general, the tribunal is the tribunal is not there for apologies or getting your job back generally, or getting someone disciplined. The tribunal is there for financial compensation in most cases. And so if they have made it right, but not made it right enough, that is, in that kind of circumstance, that's the way that I would probably think about it. Who do you put as the respondent if you went through 2Pay? Is it the new employer? I think it would be the new employer, Candy Girl. If I don't have the energy to submit a grievance, can I go directly to ACAS? I can completely understand this, Maria. The short answer is I wouldn't recommend it. However, I wouldn't recommend it. And the reason I wouldn't is because let's say that you go straight to ACAS early conciliation and you actually do have this fantastic solid case. And let's say you win. And let's say you win, I don't know, £10,000. because you technically did not follow the ACAS code of practice for grievances, then at your remedy hearing, the employer could then say, well, could you please reduce Maria's award by up to 25% because she didn't follow the grievance procedure? That is the risk of not using the grievance procedure. And the tribunal would definitely have questions about it before that as well, because what they want to see is that you have made every effort to resolve the issue before it ended up in tribunal. What I would not recommend that you do, though, and I think this is something that employers often take advantage of, is I would not wait for a internal process to finish before starting a CAS early conciliation, assuming that your deadline is near. You can run both processes in parallel, and I highly recommend running both processes in parallel. So let's say that you are a month away from your deadline for ACAS early conciliation. You can raise a grievance now. You can, a week before the deadline or something like that, assuming it hasn't progressed, it hasn't been resolved, you can then file for ACAS early conciliation and then just keep running the grievance process as well. Both can run at the same time, but I would do it. Otherwise, you could lose out on the whole point of the thing, which is, the compensation at the end. I was bullied. So Maria's following up. I was bullied at work by my new manager. I'm so sorry to hear that. They knew I had a disability and made no reasonable adjustments and then tried to play it off as they didn't know. 2 years service, great feedback, and tried to make me look as though I am a delinquent. Been signed off work since the end of last year. I can completely understand why you're exhausted, Maria. That sounds awful. It sounds like there are a lot of things that could make for a good tribunal claim. I would definitely go ahead and raise the complaint. You may have already raised a grievance, because if you've raised an issue in an email, if you've sent in a letter of complaint, your employer is required to treat that like a grievance. So if you've already done that, then you could argue that you've already raised a grievance. But if you haven't, I would put that together. I would focus on that first, and then I would start ACAS early conciliation and be very mindful of those deadlines. Okay, so Ginger Ninja is answering the question that some people had about the preliminary hearing. What's it like? She said the preliminary hearing was, oh goodness, I've clicked on the wrong thing. Actually a good experience. I wouldn't fear it at all. And someone has said, can the employer surprise you with anything at a preliminary hearing? Yes, they can. Typically what we see employers doing at PHs is asking for a strikeout. This is like a straight out of the gate, just try and smack you in the face kind of move that they often do, where they would just ask the tribunal judge, can you just throw this whole thing out because it's just so ridiculous. They have no reasonable prospect of success. That's the legal term. And therefore, can you just throw the whole thing out? And it freaks people out, quite rightly. Now, it's a very high bar to throw a case out with no reasonable prospect of success straight out of the gate. Because what that really means is that your ET1 had to be so unclear about what any legal claim could be that the tribunal doesn't even think it's worth moving forward to find. The judge had some concerns that there wasn't a clearly formed legal claim there. Then the next thing that they would likely do is either sit down with you during the preliminary hearing to better understand, they call it particularize your claims. So better understand the exact legal issues relating to your situation and help you figure it out there and then. Or they would ask you for something called further and better particulars. Now, this is all called particulars because it's the particulars of claim document that people typically attach to their ET1. And that's where they lay out the particulars of the claims. So unpaid wages as per X of the Employment Rights Act. That's what they're looking for. And so your employer could try and throw out the strikeout request, but you can always say, look, if my claims aren't clear, I am happy to work with you or work with someone else to give you better particulars. So that's, what I would think about there. So user 441 is saying how I asked about the disability impact statement. If you're always told the employer it was depression, but the doctor always marked it as clinical, should I put this in it? I don't think I completely understand, but if your doctor is saying that you have clinical depression, then absolutely you would put that into a disability impact statement. And the whole point of a disability impact statement is to show, it's to prove what the Equality Act uses as the criteria for defining a disability, which is that it has a significant impact on your day-to-day life and that it has lasted or will last for more than 12 months. And so a disability impact statement is literally filling in that significant impact on your daily life, like making that real. And so it's saying, say you had terrible back pain. I can't sit in a chair for more than 20 minutes at a time. And therefore, I can't be at a desk during this time. And therefore, I need a walking desk as an accommodation. Or, I need to have breaks every 3 hours as an accommodation. I can't sleep at night because of my back pain, and I often only get 6 hours of sleep. I have to take taxis to work because I can't sit on the bus. Those are all things that might go into a disability impact statement. Okay, so let's go back over to YouTube. Goodness, so many great questions today, and I'm going to try and get through as many of them as I can. Carla, my dismissal was intentionally fabricated by the line manager with a property manager help. Who should I claim against? The management agency only, both the agency manager plus the line manager. I have severe depression and medications, 6 months. Can I mention that when I'm filling out the ACAS early conciliation form? Yes, of course you can mention that when you're filling out this the ACAS early conciliation form, especially if you think that severe depression is an impact of what has been happening to you. Who should I claim against? So you can claim against your employer as the organization. You can also name individual respondents in a claim. So you can claim against multiple people within the one. And so if you think that the line manager in particular should be called out for what they should be, called to account for what they did, not just the company, then you can add them as a claimant on the claim. I need to talk to the coaches about this to understand like the strategy and like what the best tactics are for multiple respondents. If you need to know, I would highly recommend that you email us and ask, I want to talk to a coach about this. Can I get a coaching package? And then we'll hook you up with a coach via a coaching package, and they can help you understand multiple respondents and what the tactics are basically in Tribunal for that. But I'm afraid I don't know the details of the best ways of thinking about that, if that makes sense. My substantive preliminary hearing is next week. The respondent has denied my disability so far. So they accept that I had a disability, but not at the time I was dismissed. Yeah, so I'm trying to understand that. So this is a common thing. This is a trick that employers will use. They will say, look, I accept that Tina has a disability now, but I don't accept that she had that disability then, or I don't accept that we knew about that disability then. So this is why contemporaneous notes are so important. This is why we built a whole note. This is why we built the timeline in VALA. It was the first thing we built, because knowing when you communicated to people and said, I have back pain, terrible back pain, it's a real issue, that kind of stuff, knowing when you made those communications makes a difference, because an employer will try and slip out of disability discrimination by saying, oh, we didn't know. Or, her evidence for the diagnosis is later on, all that kind of stuff. Jazz is saying, that's what they said to me. They didn't accept that I had a disability, even though I told them. And I explained my struggles. Now they can try, but, they're going to have to make a solid case to the tribunal that they didn't know, or that you had the disability later. But that is something that I would definitely recommend doing, is using the evidence to show when you communicated what to them. The respondents didn't follow a few tribunal orders, especially when they didn't disclose so much evidence that I got a hold of via the SAR. They failed to send me the final bundle on the agreed date, since they said that the scope of the claim is yet to be finalized in next week's PH. Can I apply for a strikeout based on that, or should I send the strikeout email to the preliminary hearing or ask for the strikeout at the PH? Tina, I see people asking for strikeouts during the PH and sending it. I think you can just ask for it at the PH. They might have a point when it comes to the final bundle because the claim is yet to be finalized in the PH. It's weird that your tribunal has ordered the bundle to be completed before a substantive preliminary hearing. So I'm not surprised that they're not finalizing the bundle. However, if they are not disclosing evidence that you know was there, and if they did not disclose that as well, that's squiffy. I don't personally think, I don't know if the tribunal will strike out because of that, but if it's a part of a pattern of behavior, the thing I would really look at the employment tribunal rules of procedure, because when I say taking the piss, it's not just taking the piss against you, it's taking the piss against the tribunal. It's not following their orders in time. And especially when they ignore the orders altogether. If they have a reasonable reason, like the claims aren't finalized, then I could see them getting away with that one. But if they're not making any effort to follow the things in time, that's when a strikeout is much more like serious, or when it's much more possible. Can an employer discriminate against you because you tell them that you needed an accommodation? Yes. That sounds like, I'm assuming you mean a disability accommodation. Then yes, that's bad. that's really bad. So Patrick, I would recommend that you watch my TikTok series, since you're on TikTok, of the 6 types of discrimination. As a disabled person, actually all 6 types are available to you. It's the only protected characteristic that all 6 types of discrimination can apply to. And that's because the final 2 types of discrimination are a failure to make reasonable adjustments, which sounds like it might be very relevant to you, and discrimination arising from a disability. So that's your employer. That's the difference. Direct discrimination would be saying, I'm going to sack Patrick because he has this disability. Discrimination, and that's harder to prove because you have to show that you were treated less favorably than someone else. Discrimination arising from a disability is your employer saying, Patrick is late because he has ADHD. He asked for an accommodation, but I'm just going to sack him because I don't like that he's late. And I'm not going to work with him on that. Now, that is being discriminated against because of something that happens as a consequence of a disability. So like my back pain example, let's say I don't want to have to give this person lots of breaks, and I hate that they can't stay in their seat, so I'm going to sack them. That's not, I'm going to sack Patrick because he has back pain. That's, I'm going to sack Patrick because of something to do with the consequence of his back pain. Now, this is really important. Like, look into my eyes. This is really important because it's easier to prove in terms of the law. Because discrimination arising from a disability says that you were treated unfavorably because of your disability, not less favorably. That means that you don't have to go out and find someone else to compare to when you need to prove it. You just have to show that it was unfavorable treatment. And so if you have a disability claim, I highly recommend that you look at discrimination arising from disability and see if it could apply to you, because it is easier to prove than direct discrimination. So hopefully that's helpful. I went on a bit of a rant there, but that tip came directly from a judge, by the way. An employment tribunal judge told me that and said, pass it along. Because they often see that there is potential discrimination arising from a disability and recognize that it would be easier for claimants to actually evidence that and want people to know that that is an option. Right, let's see. Oh my goodness. So many questions. Ginger Ninja, the final bundle was submitted the day before the hearing, which was completely different from what we submitted to each other. Oh, that's not good. They've removed most of my evidence and added in witness statements. Can they do this? And then I want to resubmit everything and go through it all again due to poor representation from the previous HR advisor. Should I be penalized for this and made to do it all again? Okay, so first of all, Ginger Ninja, all the nonsense that you're telling me, definitely like strikeout application, definitely, because that's ridiculous. And they're changing it again. They're wasting the court's time. And I think that's what you really want. I wouldn't. So there's a few things. So when you make a strikeout application, look at the tribunal, especially you've bought our template. So look at the boilerplate that we put in at the end, because we put in the I can't remember what they're called. They're the reasons why it's okay to ask. I can't remember the exact legal term. Look at those and really emphasize that when you're talking about it at the PH as well, and saying, I can't remember the exact wording, but they are wasting the court's time. It's not just your time that they're wasting, but they're wasting the court's time, and that's definitely not okay. And, in the interest of fairness, so you're saying, should I be penalized for this and made to do it all over again? The tribunal kind of doesn't care about you having to spend a lot of time organizing documents, but they do care if the process has not become fair or is now not fair. So I would look at those wordings and search for those terms and see where you think that that's what they're doing wrong, and really push on that when you're making that strikeout application. My colleagues denied my social anxiety and basically denied my annual leaves. Oh God, that sounds so stressful, Gold Yeti. So again, just as a quick reminder, if you have anxiety, depression, if you have any of those things, that can count as a disability just as much as cancer, sciatica, all those things. COPD, etc. So anxiety and depression can be a disability just as much as the other things, and therefore you can't be harassed. That's one of the other 6 types of discrimination. You cannot be harassed, which is essentially bullying because of a protected characteristic. So if you are being bullied because you have a protected characteristic, that is called harassment in the Equality Act. Ginger Ninja's saying, my witness statement and references will now not match the never submitted bundle. Like, it's ridiculous. Like, it's absolutely ridiculous. Is the overriding objective, thank you, that was exactly what I wanted to check. Is the overriding objective is that it's wasting their time? So we give you the overriding objectives to pick from. I can't remember what they are, but I think there's one in there. Something about fairness. I can't quite remember, but find the one that feels appropriate, double check the Employment Tribunal rules of procedure, and then hammer that, because they are taking the piss. Like, it's ridiculous. Okay. Right. So, oh goodness, I've got a few more minutes left, and I just want to answer some more questions. Nicole, goodness, I've been made redundant with an immediate effect and the employer hasn't paid our wages. What do I do? Okay, Nicole, how many people have been made redundant? I'm Googling something for you. How many people have been made redundant? And did the company go into liquidation? If more than 20 people have been made redundant at a single workplace and the employer fails to properly inform them or engage in a consultation, then you might be able to apply directly to the tribunal for a protective award, which is basically asking the tribunal to pay. Okay, good. 20 plus. Thank you, TikTok Watch. I'm just going to put. Do I only talk about employment tribunal? Yes, for now. I would love to get into tenancy and small claims, but for now it's just employment tribunal and employment law that I can help with in England, Scotland, and Wales. Okay, so it's 8 people, and it's in the process of going into voluntary liquidation. You're very welcome, so Sonia. So as a company goes into liquidation, the employees are one of the creditors. Unfortunately, employees are not at the top of the list of creditors. So depending on how many assets are still left in the company, you might not get top priority. It's probably worth going ahead. It's probably worth going ahead and making an unpaid wages claim. I'm just looking to see. I don't think you can do the protective award, unfortunately, if it's under 20 people, because it's to do with the lack. Because over 20 people, they're required to give you a certain amount of notice, and it's basically to compensate for that. So in that case, hey Guared. So in that case, I think I would still make the claim for unfair. I'm so sorry to hear that, Nicole. No notice at all. I think it's a straightforward unpaid wages claim, and I think it's probably worth making that claim. And the other thing that I would do is get in touch with the liquidator and ask. So if they're going into voluntary liquidation, if your company goes into liquidation, there is a liquidator. Actually, wait, they can't do voluntary liquidation, because you can't voluntarily liquidate if you have creditors. You can only do voluntary liquidation if you don't have any outstanding debts. Otherwise, it's involuntary liquidation. And then in involuntary liquidation, that is when the liquidator actually takes whatever is left and distributes it out to creditors according to this criteria, and employees are kind of in the middle of that hierarchy. But they can't do voluntary liquidation while having an outstanding debt, and their debt to you would be an outstanding debt. They might try to offer you a settlement of, say they owed you £1,000. They might say, can we pay you half of that to settle this so that we can do a voluntary liquidation? So it's worth Googling the difference between voluntary and involuntary, and how can I involuntary liquidate because Klarna is chasing me? Yeah, sadly that's different. So yeah, I would definitely find out the difference, ask who their liquidator is, get in touch with that liquidator, and remember that they cannot voluntarily liquidate if they owe money to you. And that liquidator should know that. Okay, a few more questions. I'm so sorry I can't answer everything. Tenancy rights. Yeah, I really want to get to tenancy rights, Kevin. Is it possible to talk to you about a disciplinary in Scotland? I'm so seriously struggling. Oh, Nicola, I'm so sorry. Can you email us, hello@vala.uk? We don't have a particular package for disciplinary support, but we will do our best to see if we can support you through this. And then depending on what happens, we'll have some more support available after that. I've been offered judicial mediation. Is it worth trying? It depends on how good you are at a written argument, because judicial mediation is where the judge sits down, reads your arguments, and then decides, and then says, based on this, I think you've got a good chance of winning or losing, and therefore I suggest that maybe you should settle maybe for this amount of money. So if you feel based on that, I generally think that judicial mediation might not be the best option for many litigants in person, because a lawyer and a law firm are going to have a lot more resources to prepare a solid written argument. But that depends on the support that you're getting. I applied for tribunal in December. What happens next? What do I hear from next? Who do I hear from next? Grace, you will hear from the tribunal itself, and they will first send you an acknowledgement, which they've probably already sent, and then you will get an invitation. You'll probably get your the ET3 document back next. That's the employer's response to your ET1. Just to warn you, it will be awful. It will be awful to read. It will be an outright denial of everything. You do not need to respond to it. The response, there is no response to an ET3. You will handle what they say later on in the case as part of your witness statement, your evidence, and your bundle. Then you will get, assuming your case is not going to be just one day, which most cases aren't, then you will get an invitation to a preliminary hearing, and that will contain more information. If you do want help preparing for that preliminary hearing, we have a package on our website. If you go to vala.uk, click on coaching, you'll see a preliminary hearing preparation package. Are agency care workers, support workers, contractors, or workers? So often they are employees, workers. and sometimes people who are told that they don't have worker rights are actually classed as workers um, because if you have to show up in the same place for the same people every day or as your only job, it's getting really, really like you're probably a worker. So sometimes people are told that they're not actually a worker or don't have the rights of a worker when they really do. And you will see that sometimes if you look on the gov.uk Employment Tribunal decisions page, where people are saying, I'm actually classed as a worker when I didn't think I was, or something like that. Right, I actually have to go. Nicole says, thank you so much. Don't know what to do. Oh, you're very welcome. You're very welcome. I'm so sorry I can't answer more of these questions. I actually do need to go because I'm just finalizing. I think I mentioned to you all that we are doing a crowdfunding campaign so that so that people can buy shares in Vala if they want. I'm selling individual shares in Vala if people want to have ownership of the company. I want the people that Vala was built for to be able to have some ownership of the company. So we're doing a crowdfunding. We're opening up crowdfunding very soon. I'll quickly just show you the link. I don't even know if it's in our link tree yet. It's so new and we've already had such an amazing response. So what we're doing now is we're collecting anybody who's interested, and then if people are interested, the people who sign up on this will get the first notifications when we actually open up for people to buy shares if you want to do it. So yeah, absolutely no pressure. But if it is something that people are interested in, then that's the link that you can go and check it out. Amy, no, don't be worried. I have heard people having to wait for a really long time, like months, for a decision after their final hearing. So I wouldn't worry, unfortunately. You're very welcome, Ginger Ninja. And so I'm so sorry. Thank you, Toke. Does it matter that my employment only made 18 people redundant if they intended to make 15 to 30 people redundant? I think if 20 plus people were at risk of redundancy, then it probably follows that they would fall under that 20 plus category, because 20 plus people had to be notified they were at risk of redundancy. And that's the key thing. Okay, where is the link? I just put the link in, but if you go to the Cedars website, it's seedrs.com, and you go to coming soon, then you will see Vala in there. And I think we're going to put a banner on our home page as well, so that you can just click through from there if people are interested. Can I get back to my grievance even though it's been over 3 months? Yes. Back to my grievance. Can I get back to my grievance? For the people, by the people. Yes, that's exactly it. Can the judge make a ruling at the PH if one or other party doesn't show up? Yes. Look up Rule 21 judgment. Oh, you mean you disagree with the decision? Big Mama, you can make a grievance appeal. I would check the ACAS Code of Practice. A grievance appeal should be raised really soon after the grievance. It might just be working. If the issue is still ongoing, it might just be worth raising another grievance instead of appealing the old grievance, if that makes sense. Okay, right, I'm gonna go. Thank you all so much for your time today. I'm so sorry I couldn't answer all the questions. We will be doing another webinar really soon. So if you go to vala.uk and check out webinars, you can put your email address in and we'll send you an email when the next webinar is out. The next one's going to be on a topic. I can't remember which topic, and then we'll do an employment tribunal support group probably in the next 3 weeks, which is free and is so lovely. Okay, right. Thank you all so much. Have a wonderful evening, and I'll talk to you soon. Bye-bye. Bye-bye, YouTube crew. Great to see you. Thank you so much for coming.